For those who keep on insisting that the Lindsay Clancy trial was only ever about whether Lindsay was criminally responsible or not, it's time to stop spinning the block. A lot of legally savvy people, including attorneys, have gotten on here and explained time and time again that although those are the most likely outcomes available based off of everything we've seen, there are more options available to the jury. But maybe you'll listen now that it's come straight from the court, who just had its formal charge conference before recessing for the day. That's where the judge and the attorneys discuss the law and the jury instructions that will be given to the jury tomorrow. We're going to recap what was discussed, including the lesser charge that Judge Sullivan has now agreed to place before the jury. So grab a drink, let's get started. Let's start with what Judge Sullivan confirmed will be included. The jury will receive instructions on 3 counts of first-degree murder under 2 separate theories: deliberate premeditation and extreme atrocity or cruelty. The jury does not have to be convinced of both theories. The instructions will also include second-degree murder. That means a guilty verdict does not automatically mean the jury found deliberate premeditation. The court will also give the standard instruction on lack of criminal responsibility. And this part is crucial. Lindsay does not have to prove that she lacked criminal responsibility. Once that issue had been properly raised, the Commonwealth had to prove beyond a reasonable doubt that she was criminally responsible when the killings occurred. If the jury has reasonable doubt about whether the Commonwealth proved criminal responsibility, the appropriate verdict would be not guilty by reason of lack of criminal responsibility. Judge Sullivan will also explain that this verdict would not mean Lindsay simply walks free. It begins a court process that can lead to her commitment to a mental institution if she is found mentally ill and dangerous. Now, the biggest development from this conference is that the judge is indeed going to give the jury an instruction for the lesser charge of manslaughter. The defense originally argued for involuntary manslaughter based on wanton or reckless conduct. Reddington then also argued that Lindsay's mental impairment and the effects of her prescribed medications could have reduced her ability to form the intent required for murder and could support voluntary manslaughter. The Commonwealth objected to a manslaughter instruction altogether. Its position was that strangling the children was conduct so likely to endanger life that the evidence could not reasonably support involuntary manslaughter. Judge Sullivan ultimately indicated that he will give one general manslaughter instruction, without labeling it either voluntary or involuntary. That instruction will allow the jury to consider evidence of mental impairment and the consumption of prescription medications when deciding whether the Commonwealth proved the intent required for murder. We will need to see his revised written instructions tomorrow for the exact language, but manslaughter is officially going to the jury as a possible verdict. There will not be a voluntary intoxication instruction. Interestingly, both sides agreed on that. They agreed that there was no evidence that Lindsay voluntarily intoxicated herself in the traditional sense by intentionally abusing alcohol, drugs, or medication. That is different from the defense's argument that prescribed medication may have affected her mental state and her ability to form the intent required for murder. The jury may still consider that evidence within the manslaughter instruction Judge Sullivan plans to give. Reddington also requested a Bowden instruction, or Bowden, depends. Both sides were pronouncing it differently during the conference. A Bowden instruction would have specifically told jurors that they could consider alleged deficiencies in the police investigation when deciding whether the Commonwealth proved its case beyond a reasonable doubt. Reddington argued hard that police accepted Lindsay's involvement almost immediately and failed to investigate or properly test several pieces of physical evidence. He argued that those deficiencies could create enough reasonable doubt to support a general verdict of not guilty. And I want to pause there because people keep saying a general not guilty verdict was never legally available in this case. That is simply not true. Was that verdict highly unlikely based on how the defense presented its case? Yes. But highly unlikely and legally unavailable or impossible are not the same thing. The Commonwealth objected to the Bowden instruction, and Buckingham argued that the investigation was adequately documented and that Reddington could make his arguments during closing without receiving a separate jury instruction, and Judge Sullivan ultimately agreed with the Commonwealth. He will not give the jury a separate Bowden instruction, but Reddington will still be allowed to argue that deficiencies in the investigation create reasonable doubt. And the denial of that special instruction does not remove a general not guilty verdict from the jury's consideration. The jury will also be warned that documents, photographs, or messages appearing in evidence more than once should not automatically receive greater weight simply because they were presented multiple times. So what does this all mean for the possible outcomes? Well, the jury could find Lindsay guilty of first-degree murder. It could find her guilty of second-degree murder. It can now convict her of the lesser offense of manslaughter. It could return a general verdict of not guilty if the Commonwealth fails to prove the required elements for the charged offenses beyond a reasonable doubt, or it could find her not guilty by reason of lack of criminal responsibility if the killings were proven, but the Commonwealth failed to prove that she was criminally responsible. And although it will not appear as a choice on the verdict sheet, the jurors could be unable to reach a unanimous decision on one or more counts. In other words, the jury could hang. That could create the possibility of a mistrial on any unresolved counts. And technically, because Lindsay is facing 3 separate murder counts, the jury could reach different conclusions for different children. That would be a mixed verdict. But I doubt that that's likely because both sides largely presented the 3 deaths under one unified theory, rather than arguing that Lindsay's mental state or criminal responsibility changed from one child to the next. But it remains legally possible, so I'm just throwing it in there. So no, this case has never been limited to only guilty or not criminally responsible. There are now at least 5 verdict options available to the jury, plus the possibility that they hang on one or more counts. So what do I think is going to happen? The only thing I can tell you for certain in the 20 years I've been watching court trials is that juries are incredibly unpredictable. On the outside, we remember the highlights, we've seen outside evidence, reconstructions, think pieces. We are ruminating on this day in, day out, and hearing different perspectives. They are only exposed to evidence, testimony, evidence that's legally admitted, testimony. They are told what to disregard, and then they are going to be given the law that Judge Sullivan is asking them to apply in this case. That is it. So they have a very limited view, I wouldn't say limited, but a very different perspective than what we have. So they may see this case very differently from us. But I still want to hear your thoughts. Get in the pretend jury box with me and tell me what you think the verdict is going to be. I'll be reading your comments. And as always, like, comment, share, subscribe, do all of the things. I will be back with tomorrow's recap of closing arguments. I'll catch you in the next one.